imagine a gripping courtroom drama. Someone's fate hangs in the balance, and it all comes down to their own words, something they said. Sounds simple, right?
Well, yes and no. In the real world of law, it's rarely that straightforward.
Exactly. Statements aren't always what they seem. Was it voluntary? Could it be twisted? And who said it? When? Under what pressure? So many questions.
Precisely. The power of a statement in court is, well, immense. But because of that, there's this incredibly detailed legal framework built around it. It's all about fairness and reliability.
It's a real tightrope walk.
It really is.
And that's exactly where we're headed today. We're doing a deep dive into the intricate, sometimes really surprising world of admissions and confessions under India's brand new legal framework, the Bharatiya Sakshya Adhiniyam, the BSA 2023.
That's the one. It's the law that just replaced the old Indian Evidence Act, which had been around for, well, ages. A huge change.
So our mission today for this deep dive is to really unpack these key ideas, admissions, and confessions. We want you to get not just what they are, but how they work as evidence.
Yeah, and the really strict rules about whether they can even be used in court.
Yeah.
And crucially, why the law is so specific about all this. It's all about balancing things, ensuring fairness.
We'll look at who can make these statements, what makes them count legally, and why some things people say are just, well, thrown out. Totally irrelevant, legally speaking.
Right. Think of this as your shortcut to getting truly clued in on this pretty complex but vital part of the law.
Okay, so let's kick things off. Where do we start?
All right, let's lay the foundation first. What exactly is an admission? The BSA defines it quite broadly, actually. It's basically any statement someone makes, could be spoken, written down, even in an email or a text,
Okay.
that suggests something, suggests an inference about a fact that's being disputed in the case, or just a relevant fact generally. It's seen as a major category of relevant evidence.
So it's a pretty wide net. But I guess the big question for, our listener is, whose words actually count? I mean, can anyone say something and have it used as an admission against them, or even for them?
No, definitely not. And this is where Section 15 of the BSA gets really precise. It gives a very specific, exhaustive list of people whose statements can be legally considered admissions. This section is key.
Right.
Because, the value of an admission really depends on who said it and when. The most obvious case, of course, is the actual parties involved in the court case.
Like the defendant in a civil suit.
Exactly. Say a defendant in a civil case admits they owe the money. That's a classic admission, straightforward.
Okay, so the people directly involved. That makes sense. But it gets trickier, right? Who else is on this list?
Oh, absolutely. Think about agents, like a company manager making a statement as part of their job. Their words could potentially bind the company.
Ah, okay.
Or consider someone acting in what's called a representative character, like an executor of a will.
Yeah.
Now, their statements only count as admissions if they were made while they were actually acting as the executor.
Oh, I see. So timing is crucial there.
Hugely crucial. A statement they made before they officially became the executor, that wouldn't count against the estate later. It's all about the role and the timing.
That's a really important distinction. So the capacity in which they speak matters. Who else?
Well, the law also includes people who have a direct financial or property interest in the case. Like, imagine two co-owners of a piece of land arguing about the boundary. What one says could be an admission.
Okay.
And this is an interesting one. Statements made by people from whom the current parties derive their interest.
What does that mean exactly? Like inheriting something?
Sort of. Think about property again. If the previous owner of a house made a statement about, say, a right-of-way across it, that statement could be used as an admission against the person who currently owns the house because they derive their title from that previous owner.
Wow, so the words can almost stick to the property itself. That's fascinating. Any other categories?
Yeah, a couple more. There are persons whose position or liability needs to be proved as part of the case against someone else. Think of a situation with a principal debtor and a surety, like a guarantor. A statement by the principal about the debt might be admissible against the surety.
Right, because their liabilities are linked.
Exactly.
Yeah.
And finally, if one party tells someone to go ask a specific third person for information, says, go ask Sarah, she knows what happened, then whatever Sarah says can become an admission against the person who referred them to her. It's like you're vouching for their statement in advance.
That is quite a comprehensive list. Really shows how broadly admission can be interpreted, depending on the person and the context. So, okay, we know who can make them, but here's the tricky part maybe. When are these statements actually relevant in court? Because usually you can't just stand up and use your own statement to help your case, right? You can't just manufacture evidence for yourself.
You've hit the nail on the head there.
Yeah.
That's a core principle of Section 21 of the BSA. The general rule, absolutely, is that an admission cannot be proved by or on behalf of the person who made it. You can't create self-serving evidence.
Makes sense.
But, and this is where it gets really interesting, the law carves out some very specific, surprising exceptions, situations where, despite being self-serving, the law considers the admission inherently reliable enough to be allowed.
Okay, I'm intrigued. What are these surprising exceptions? Give us an example.
Well, one major exception covers statements that are already considered relevant under other specific rules of evidence in the BSA. Think about things like dying declarations, or statements made in the ordinary course of business, or statements made against the maker's own interest at the time.
Oh, okay.
If an admission happens to also fit into one of those categories, which have their own built-in reasons for reliability, then it can be proved, even if it helps the person who made it. The law basically trusts the specific circumstances in which it was made.
So, if the statement is reliable for another reason, the self-serving aspect doesn't automatically disqualify it. What else?
Another key exception deals with statements about someone's state of mind or body at a particular time, like their intention, their knowledge, or even a physical feeling like pain.
Okay.
Such a statement can be admissible if it was made at or around the time that state of mind or body existed, and this is important, it was accompanied by conduct that makes it seem very unlikely to be faked.
Like someone crying out in pain right after an accident.
Exactly. That's a perfect example. That cry of pain, even though it clearly serves their interest in proving they were injured, is considered reliable because it's spontaneous, it matches the event, and it's accompanied by, the physical reaction.
Right. It's almost involuntary. Makes sense.
Precisely. And the last broad exception is for statements that are relevant for some other purpose, besides just being an admission. Maybe it's part of the res geste, part of the event itself, or maybe it helps explain other facts, or it's needed to contradict or support what a witness says.
Okay, so lots of layers there. Now, if admissions are generally seen as strong evidence, usually because they go against the person's interest, what's their actual impact in court? Is admitting something like, game over?
That's a really good question. Yeah. It's important to be clear. Admissions are powerful, yes. They are not usually conclusive proof. They don't automatically win the case.
Okay.
But they carry significant weight. A clear admission can definitely shift the burden of proof. The person who made it might now have to explain it away or disprove it.
Right, it puts the onus on them.
Exactly. And in some specific circumstances, an admission can act as what's called an estoppel, which basically means the person who made the admission might be legally prevented from denying it later, especially if someone else relied on that admission and acted on it.
Okay.
So yeah, a very powerful tool.
Definitely sounds like it. Okay, so we've dug pretty deep into admissions, but there's that other word that gets used all the time, especially, in crime dramas, confession. People often use them interchangeably, but in law, they're really distinct, aren't they?
Oh, absolutely distinct. This is a fundamental difference you need to grasp. Think of it like this. Every single confession is technically an admission because it's a statement.
Okay.
But, and this is the key, not every admission is a confession. A confession is a very specific type of admission. It only happens in criminal cases.
Ah, criminal cases only.
Yes, and it's where the accused person directly and clearly acknowledges their guilt for the crime they're charged with. It's about admitting the offense itself.
So scope is one big difference. Admissions are broader, civil, criminal, any kind of inference. Confessions are narrow, only criminal, only about guilt. What else sets them apart?
Well, the nature of the statement itself. Admissions can just be statements of fact. They don't have to be incriminating. As we saw, some can even be self-serving under those exceptions.
Right.
Confessions, on the other hand, have to be direct acknowledgments of guilt. They're always inculpatory, meaning they implicate the person making it in the crime. Unequivocal.
And who can make them? That list for admissions was quite long.
Yeah, admissions can come from all those people we listed under Section 15 parties, agents, people with an interest, etc. But a confession, it must be made by the accused person themselves in a criminal case.
Okay, only the accused.
And their evidentiary value is different too. Admissions, as we said, aren't conclusive, but shift the burden, maybe lead to estoppel. A confession, however, if it's proven to be voluntary and true, can, in theory, be the sole basis for convicting someone. Though, as we'll get into, If it's retracted, it needs strong backup.
Backup evidence, right. And I guess they're covered by different sections of the BSA.
Totally different sections. Admissions are mainly sections 15 and 21. Confessions are dealt with under specific, much stricter provisions, like sections 22, 23, and 24, and maybe the biggest difference, voluntariness.
Yes.
For an admission, whether it's voluntary mainly affects how much weight the court gives it. It doesn't automatically make it inadmissible usually. But for confession, voluntariness is everything. If it wasn't voluntary, it's inadmissible. Full stop. No ifs, ands, or buts.
That stark difference really highlights how seriously the law treats confessions. And it leads us right into this major area, often controversial: the safeguards against coercion. Why are some confessions just thrown out, even if they sound convincing?
Right. Now we're getting to the heart of criminal evidence law regarding confessions. The law is deeply, deeply suspicious of confessions that weren't made freely. Section 22, subsection 1 of the BSA is huge here. It basically says a confession is irrelevant, inadmissible, if the court thinks it was caused by any kind of inducement, threat, or promise.
Inducement, threat, or promise.
Yeah. This isn't just a technical rule. It's fundamental to a fair trial.
So what's the core problem it's trying to solve? Is it just that the confession might be unreliable, untrue?
That's part of it, definitely. Unreliability is a major concern, but it's deeper than that. It's about the integrity of the justice system itself.
How so?
Well, imagine someone confesses because they're terrified of being beaten, or because they've been promised bail if they just cooperate. That confession isn't a reflection of truth. It's potentially an act of desperation or manipulation. Allowing evidence obtained like that would, frankly, corrupt the whole process. It undermines the very idea of justice.
So these terms, inducement, threat, or promise, they seem clear, but how does the law define them to avoid ambiguity?
Good point. The law looks at them carefully. An inducement could be offering some kind of benefit, maybe a lighter sentence, better treatment in custody, maybe even help for their family. A threat is about instilling fear, could be physical violence, threats of longer detention, harm to loved ones. And a promise is an assurance of some positive outcome, like dropping other charges or granting a pardon.
Okay.
Now, for confession to be kicked out under this rule, it's not enough for one of these things to just exist. The law says all 4 specific conditions need to be met.
4 conditions, what are they?
1, there has to be a direct causal link. The inducement, threat, or promise must have caused the confession. 2, it must relate specifically to the charge the person is facing. 3, it must come from a person in authority.
And who counts as a person in authority? Just the police?
No, it's interpreted quite broadly. Police, magistrates, prosecutors, yes. But it could also be, say, an employer or even the victim or their family if they're in a position to influence the prosecution or the accused situation.
Okay, broad definition there. And the 4th condition?
The 4th is that the inducement, threat, or promise must be significant enough that the accused reasonably believe they'd gain some kind of worldly advantage or avoid some kind of worldly evil by confessing. Not a spiritual benefit, but something tangible in this life.
That's a very specific set of criteria. Seems designed to ensure it's a serious influence, not just a minor comment. And proving the confession was voluntary, that burden is on the prosecution, right?
Absolutely. It's a heavy burden on the prosecution. Often the court will hold what's called a voir dire. It's like a mini trial within the main trial, specifically to determine if the confession was voluntary before deciding if the jury can even hear it.
Okay. But even if a confession somehow gets past that hurdle, there's another huge barrier, isn't there? Section 23(1), confessions made directly to a police officer.
Yes, this one is an absolute ironclad rule. Section 23, subsection 1 states very clearly, no confession made to a police officer shall be proved as against a person accused of any offense. It's completely unqualified.
Wow, no exceptions there. Why such a drastic absolute ban? What's the deep reasoning?
This section is really a cornerstone of Indian evidence law, rooted in historical experience. During the colonial era, there were widespread concerns, frankly, about police brutality and using third-degree methods to force confessions. So this rule was brought in as a powerful disincentive. If a confession made to police is automatically inadmissible, it removes the primary motivation for using coercion to get one. It's a massive safeguard for the accused, protecting against self-incrimination when they're most vulnerable in police custody.
So it's about preventing torture and ensuring due process.
Exactly. And it also reflects a deep skepticism about the reliability of any statement made in the inherently intimidating environment of a police station, even if it looks voluntary on the surface. The potential for subtle pressure is just seen as too high.
And this term police officer, does it only mean the regular police force?
No. The courts have interpreted police officer quite broadly here, too. It includes not just the state police, but potentially officers from other agencies who have similar powers of investigation, arrest, search, and seizure, like customs officers, railway protection force, maybe even narcotics control bureau officers, depending on their specific powers under their respective laws.
So it's about the power they wield, not just the uniform.
Precisely. The prohibition is absolute regarding statements made to them in that capacity.
Okay, so confessions made directly to police are out, period. But surely there must be situations where statements made while in police custody can be used. Are there any exceptions to these strict rules?
Yes, there are. Even with these strong protections, the law recognizes the need for evidence. So it carves out a couple of very specific, tightly controlled exceptions where statements made in custody might be admissible.
All right, what's the first one?
The first major exception is in Section 23, subsection 2. It says that a confession made by someone while in police custody is admissible if it's made in the immediate presence of a magistrate.
The magistrate again. Why is their presence the key factor here?
Because the magistrate is seen as the independent judicial buffer. They're separate from the police investigation. Their presence is meant to guarantee that the confession is truly voluntary, free from any police influence or coercion. They act as a safeguard.
It neutralizes the police custody environment in a way.
That's the idea. And there's a very strict procedure the magistrate has to follow when recording such a confession, laid out in Section 164 of the Code of Criminal Procedure, the CRPC.
Right, you mentioned the CRPC earlier. What does that procedure involve?
It's quite rigorous. The magistrate must first warn the accused that they don't have to confess, and that if they do, it can be used against them. They have to question the accused to make sure they're confessing freely, without pressure. They usually have to give the accused time to think, often sending the police away for a while.
Time for reflection.
Exactly. And crucially, the magistrate has to make a formal record, certifying that they are satisfied the confession was voluntary. And, critically, the investigating police officer is absolutely barred from being present during this recording.
That sounds like a very thorough process, really trying to balance getting evidence with protecting rights.
It is. It's the law's attempt to find that balance.
Okay, so that's the magistrate exception. What's the second big exception to the rule against custodial statements?
The second one is in Section 23, subsection 3. This is often called the discovery section, and it's really fascinating. It works on a principle called the doctrine of confirmation by subsequent events.
Confirmation by subsequent events. Sounds interesting. How does it work?
Basically, it says that if an accused person, while in police custody, gives some information, and as a direct result of that specific information, a relevant fact is discovered, like the police find the hidden murder weapon, or stolen goods, or even a body,
Okay.
then so much of such information, as relates distinctly to the fact thereby discovered, may be proved.
So the discovery itself kind of proves that part of the statement was true. It's not just words anymore.
Exactly. The subsequent discovery lends credibility or confirmation to the specific part of the statement that led to it. But, and this is vital, the conditions are very strict.
What are the conditions?
First, the accused has to be in police custody when they give the information. Second, a fact must actually be discovered. Third, the discovery must be a direct consequence of the information given, not something the police already knew or found by chance.
Direct consequence. Okay.
And fourth, and this is the most crucial bit courts scrutinize, only the precise portion of the statement that distinctly relates to the fact discovered is admissible. Nothing more.
Can you give an example to make that distinctly relates part clear? It sounds like a fine line.
It absolutely is. Let's use a classic example. Suppose the accused says, while in custody, I killed Ram and hid the knife I used under the big rock in my garden. The police go to the garden, look under the big rock, and find the knife.
Okay.
Under Section 23, the part of the statement, the knife I used is under the big rock in my garden, would likely be admissible because it distinctly led to the discovery of the knife. But the first part, I killed Ram, which is direct confession of guilt, would generally not be admissible under this section because it doesn't lead to the discovery of the knife. It's only the information leading to the fact discovered that gets let in.
That's a critical distinction. It prevents the whole confession from slipping in through the back door of a discovery.
Precisely. It's meant to be narrow. And this section gets particularly messy when you have multiple accused people, leading to what's called the joint statement problem.
Ah, yes. How does that work? If several people are arrested and one person's statement leads to a discovery, can it be used against everyone?
Generally, no. This is a major point of caution for courts. Section 23 is seen as applying individually. There isn't really a concept of a joint discovery in this context.
So one person's discovery statement doesn't automatically implicate the others.
Correct. The prosecution has the tough job of proving which specific accused provided the actual information that led to the discovery. If it was a vague statement attributed to the group, courts are very hesitant to use it against anyone individually. They need clear authorship.
Makes sense. There's a real risk of unfairness otherwise.
Absolutely. Courts are very wary of police potentially fabricating discoveries or wrongly attributing the crucial information, especially when dealing with multiple suspects. They demand clear proof connecting a specific individual statement to the specific discovery.
So a high burden on the prosecution there. Okay, this naturally leads us to another complexity. What happens when one accused person's confession directly implicates other accused people in the same trial? Shared blame.
Right. This scenario is specifically addressed by Section 24 of the BSA. It lays out the rule for using a confession made by one accused person against a co-accused in the same trial.
What does it say?
It says that when two or more people are being tried jointly for the same offense, and one of them makes a confession that affects both themselves and one or more of the others being tried with them, then the court may take that confession into consideration against those other co-accused as well.
May take into consideration. That wording sounds cautious, like it's not automatic proof.
Exactly. That phrase is key. It signals immediately that this is not primary evidence against the co-accused. But first, there are strict conditions before it can even be considered at all.
What are the conditions for Section 24 to apply?
Okay, first, there must be a joint trial. They have to be tried together. Second, it must be for the same offense or offenses so connected they form part of the same transaction. Third, one accused must make a proper, voluntary, admissible confession. It has to be a valid confession against the maker first.
Okay.
Fourth, that confession must implicate both the person making it and the co-accused against whom it's being considered. And fifth, the confession has to be properly proved in court against the person who made it.
So even if all those conditions are met, you said it's not primary evidence against the co-accused. What does take into consideration actually mean in practice?
This is probably the most critical takeaway about Section 24. It means that a co-accused confession cannot on its own be the basis for convicting the other co-accused. It's not substantive evidence against them.
Not substantive evidence. So what is it then?
It's considered merely corroborative. It can only be used to lend support or assurance to other independent evidence that already points towards the guilt of the co-accused. Think of it as maybe strengthening evidence that's already there, but it can't stand alone.
Like a supporting beam, but not the foundation?
That's a good analogy. It can help the judge feel more confident in the conclusion already suggested by other evidence, but it can't build that conclusion by itself.
Why is the law so wary of this type of evidence? It seems like a confession implicating someone else would be powerful.
It's treated with extreme suspicion for very fundamental reasons related to fairness. Firstly, the person making the confession isn't giving evidence on oath in the trial of the co-accused.
Right.
And secondly, and this is huge, the co-accused against whom the confession is being considered has absolutely no opportunity to cross-examine the person who made the confession about that statement. That violates a core principle of natural justice, the right to challenge evidence against you.
No cross-examination. That's a major procedural safeguard missing.
Exactly. Plus, there's always the risk that the person confessing might be motivated to lie or exaggerate the role of others to minimize their own guilt or, curry favor with the prosecution.
So the courts apply a strong rule of prudence here.
Yes, consistently. The Supreme Court of India has repeatedly stressed that it's highly unsafe to base a conviction solely on a co-accused's confession. It requires independent, reliable corroboration connecting the co-accused to the crime. It can only lend assurance if other solid evidence already exists. Courts are, quite rightly, extremely cautious.
Extreme caution is definitely needed there. Okay, so that covers co-accused confessions. Now, what about a situation that must be a real headache for judges? The retracted confession. What happens when someone confesses, maybe even before a magistrate, but later takes it back?
The retracted confession. Yes, that presents a significant judicial dilemma. A retracted confession is exactly what it sounds like. One that was initially made, maybe properly recorded, but the accused later withdraws it, denies it, or claims it was false or obtained improperly, maybe through coercion, misunderstanding, or bad advice.
So the act of retraction itself immediately casts doubt on the original statement.
It absolutely does. It fundamentally undermines the presumed reliability of the original confession. When a concession is retracted, the court's job becomes much harder. It has to conduct a careful, twofold inquiry.
Twofold. What does the court need to examine?
First, it must re-examine the voluntariness of the original confession with even greater scrutiny. Was it truly free from any inducement, threat, or promise, despite the later denial? And second, even if the court believes it was voluntary, it must then assess its truthfulness. Is this retracted confession actually true? Does it align with other independent evidence in the case?
So voluntariness and truthfulness both have to be established again, even after the retraction.
Yes, and the burden remains squarely on the prosecution to prove both, which is obviously much harder now that the accused denies it. This leads to the crucial requirement: corroboration.
Corroboration again. Is it legally required here?
While maybe not an absolute rigid rule of law in every single instance, it's become a near universal rule of prudence. Courts almost invariably insist that conviction cannot be based solely on a retracted confession. It must be corroborated by other independent, credible evidence on material points.
And that corroboration needs to link the accused to the crime independently.
Yes, the corroborating evidence can't just confirm minor details. It needs to connect the accused directly to the commission of the offense, and it must come from sources other than the confession itself. It needs external validation.
So the court really has to look at why the person retracted it too, I imagine.
Definitely. The court has to carefully consider the reasons the accused gives for retracting claims of police pressure, misunderstanding, getting legal advice later, and assess how credible those reasons seem in the circumstances. So practically, courts apply that twofold test we mentioned. 1, was it voluntary? If no, it's out. 2, if yes, is it true? And that's where corroboration becomes essential.
So a retraction acts like a big red flag for the court.
Exactly. A major warning signal demanding extreme caution and independent verification. It turns what might have seemed like solid evidence into something very problematic.
Okay, wow. We have covered a lot of ground. Let's try and sort of unpack what we've learned today.
Let's recap.
We've navigated this really intricate landscape of admissions and confessions under India's new BSA. We went from the broad idea of any statement suggesting a fact and admission right into the very specific, highly guarded area of confessions, direct acknowledgments of guilt in criminal cases.
And we saw how the law draws these careful lines who can make these statements when they actually matter in court, and all the strict safeguards built in. Rules about police officers, magistrates, discovery, voluntariness.
Exactly. It's all designed to ensure fairness and make sure the evidence is reliable before it can impact someone's liberty.
So hopefully you, the listener, now have a much deeper understanding not just of the definitions, but of the why behind them. Why are confessions treated so differently from admissions? Why the absolute bar on confessions to police? It's about that constant balancing act.
Balancing the need to find truth with the fundamental need to protect individual rights. You've seen the history behind these rules and the core principles of justice at play under this new BSA framework.
It's not just abstract legal stuff. It's about the mechanisms that try to ensure justice is done fairly and reliably.
So considering all this incredible detail, the history, this constant balancing act we've talked about, here's a final thought for you to ponder. How do you think emerging technologies might change things?
Interesting question.
Things like advanced AI analyzing statements for veracity, or maybe even biometric lie detection, if that ever becomes truly reliable. Could these technologies complicate or maybe even clarify these age-old legal ideas about what's voluntary or truthful?
Yeah, what new challenges might arise? What new questions about consent, coercion, or even the nature of a statement itself when technology gets involved? Something to think about.